Well, hello, everyone. Welcome to our webinar. This one is A Loved One Has Died, Now What? And thank you for joining us. Our lawyer, Adam Burke, is going to do the lion's share of this presentation. And then when we reach the end of the presentation, we'll let everybody share their screen if they'd like. We're going to keep recording, but we'll let everyone share their screen if they'd like, and we will take questions. And but we're going to record the questions because we get some of the most interesting information into the webinar as answers to questions. So everybody, here's Anna.
All right. Hi, everyone. Thanks for joining us this evening. I'm going to share my screen here and just get situated so you can see our PowerPoint. Just give me 1 second. Everyone should be able to see this now. Here we go. All right. So, hi to everyone here. We are here because we are worried about what happens if someone that we love passes away. There are a lot of questions that come with that process, both legal, social, and emotional. Barbara is going to speak to the emotional element tonight and what comes with that at the end of this presentation. But I am going to be speaking to the legal questions that come with this. So these are things that normally people do not want to think about. Where does the money go of that person who passed away? Who gets the home? The personal belongings. Who gets the guitar collection? Who gets the wedding ring that mom or dad wore for 50 plus years? What property passes through a will or a trust? Some of these people may or may not have heard those two words before, but I'll be digging into them deeper tonight. And what property doesn't pass through a will or a trust, if so? These are questions that are very valid that we hope to answer for you tonight. And so it also comes with, strained relationships. No family is perfect, or as my father says, every perfect family is imperfect in their own perfect way. And so we'll be addressing some of those. And so the most important question is, should you do estate planning? And the short answer is yes. And the second bullet point really answers that question. If you don't have a will or any estate planning in place, for that matter, the state of Tennessee has a plan for you. And that plan is called intestacy. Basically, what that means is if you die without any sort of estate planning document in place, the state of Tennessee has a statute that basically comes into effect upon your passing, and it governs how your property is to be distributed after your death. It's worth noting that, we live in the technology age, and, with innovations in technology, specifically AI, there are a number of forms that are available online. I know there's a couple companies that come to mind, which I won't name, but people ask me all the time, should I just do online forms? You certainly can have an online form created. But one of the drawbacks is that you don't have a lawyer reviewing that. Every legal situation is different. And it's worth having that conversation with a lawyer just to determine, am I making sure that my plan is the plan for me? What if you have a child or a family member that is receiving government benefits, or is handicapped or disabled in some way, shape, or form? You can't just leave them an outright gift if they're receiving benefits. Or if you have a large estate, there could be potential tax consequences. So these are some of the things that we'll be discussing. So, probate, the magic word that everyone does not like to hear because everyone wants to avoid it. What exactly is it? Probate is basically a court-supervised process during which an estate is settled. So, It occurs normally when you die with a will. Normally, you want to probate the will. It also governs the process by which you are petitioning the court to probate an estate of someone who died without a will. There's that word again, intestate. So that's where those words normally come from. How it works in Tennessee normally is someone passes away with a will, and if assets need to be probated and they need letters to show that this asset needs to go to this specific person, then we have to petition the court and formally open the probate process. How it works in Tennessee: you sit with a lawyer and you say, do I need to probate this estate? We walk through everything and then we say yes or no. If we do need to probate the estate, then we start by drafting a petition and filing that with the court along with other supplementary documents. Once those are filed, a hearing is set to determine whether or not the estate can be opened or not. Once the court says, okay, we've checked all the boxes and we can open this estate, the estate is formally opened, to which there is an order that is signed by the court saying that this estate is opened. This second bullet point here, letters testamentary. These are the letters. Really, it's just one letter, but the court likes to use its fancy language. It's one letter that is basically issued to the executor of the estate that gives them the authority to act in their capacity as executor on behalf of the estate. So a really good example is, mom or dad had a bank account at Bank of America, but it didn't have a beneficiary designation. So hold that thought. But they died. There's no beneficiary. It's technically part of their estate. You go as the son or daughter and say, hey, mom died. I need this money. And they say, no, we need letters testamentary in order for that to flow to the estate. That's where these letters come in. They would give you the authority for many of the major institutions to act on behalf of the estate. Basically, it allows you to be recognized as executor. Right after that happens, we pay something called a publication notice fee. And the publication notice basically allows creditors to be notified that that person has passed away. So if there's, credit card bills or utility bills, sometime, depending or not, they may or may not file, but it allows them to step forward and file a formal claim in probate. The creditor period in Tennessee lasts for 4 months. And so this gives creditors 4 months to step forward and file a claim. If creditors do not file a claim within that 4-month period, they are barred from filing a claim. The only exception to that is TennCare, which is Tennessee State Medicaid. So on that note, if you file a notice to creditors and someone was receiving TennCare benefits, the TennCare technically has 12 months from the date that was filed. So notice how it's an 8-month extension. That's the only major exception to that rule. But again, it allows creditors to come forward. Once that publication notice has been published, either in the Tennessean or the Nashville Ledger, then comes the execution period, which is basically whoever is named executor doing their job. So it's, if you've determined what assets are in the estate, or, mom died with a car in her name and I need to move it over to me, or I want to purchase it, or I want to sell the car, or I need to go to a bank and just deal with them, or it's Charles Schwab or Vanguard or whatever the case may be, you would run around with those letters and you would say, hey, I'm the executor and I need to move this money over to the estate. And that's worth also noting. During this time, you would open an estate account. So it's basically a bank account, which is in the name of the estate, so the estate of Adam Burke, right? My executor would open that account in my name, and any funds which are part of my estate would be deposited into that account. Most institutions are, pretty welcoming to opening estate accounts. There's a number of them in town. Any of the major banks will do it, no problem. But you just basically hold that account like any other. And then once it comes time to distribute everything, that fourth node, From there, you would just distribute the money to whomever was owed their money, that whoever was named in the will. And once that is all said and done, then you would move about closing the estate, which just means receiving signed documents from everyone who is entitled to receive under the will. And once that is done, we file a closing order and probate is closed. One thing worth noting about probate is that I've said that that creditor period runs for 4 months. So right after that 4-month period is when distributions can be made and the estate can be closed. So probate can generally, if you wanted to, last a little over 4 months, right? If you're very timely and things are all said and done. But Barbara and I, in our experience, have seen it last upward to 2 years, depending on some cases. So it has that note of, I don't want, if I want to be dealing with or if I don't want to be dealing with the court, then maybe probate is something I want to avoid. And so one thing that estate planning can do is it gives you certainty about what you want and how you want your property to flow, and it makes things easier for your heirs. Sorry, how do I? Oh, yeah, there we go. Perfect. Sorry. One thing that I mentioned earlier about the online forms is that you don't get that review with an attorney, and that's a very important note. If you want to avoid probate and you want to make sure that your kids or your family members or whomever you name in your will does not have to contact someone like myself or Barbara or any other attorney in town, you might want to avoid probate. And so you might want to establish a trust for that purpose. You'll be able to choose your fiduciary, whether that's your executor under your will or your trustee. If you have minor children, this is very important. If you died intestate, there's nobody that you would have named that would have stepped in to become that guardian of that minor child. And so in your will or your trust, you're able to do so. And one of the most important things, you get to decide who receives what. I always point to this guitar in my meetings because this is one of my pride and joys. And I don't necessarily want, a cousin receiving that. I might want one of my best friends to do that, And so you're able to list that in your will or your trust. Consulting with a lawyer to help define the issues also allows you to identify and recognize if there will be any potential challengers to your will. There's a whole separate slide on will contests, so I'm going to park that, but it's just important to kind of get a sense of the lay of the land and, see, are there any shady characters that might want to step in and ask for a little more than they might have been receiving. And then one of the main things is just by doing estate planning and, executing a will or a trust, you avoid the intestate distribution scheme, which is very set. Basically it's to children. If no children exist, then to parents, then to their children, and so on and so forth. So you get to avoid that. There are other formalities that are included. There's a number of legalese that's included in our documents that does things like waive bond, and there's formal requirements in court for inventories and accountings, to name a few. Those are all waived in our documents. And lastly, you get to consider all of the possibilities. What if we all go down in a plane crash? What if mom gets sick suddenly and mom's the healthy parent? What if my spouse just got a diagnosis or something to that nature? These are all things that we can discuss in our meetings. Some people know these things right off the bat and know exactly the direction that they have to go, but you get to discuss all of them. And really, you avoid the headaches. One of the major things that Barbara and I hear all the time is, someone comes to us and something has occurred, someone's died, and they had no planning in place, whether that be a single person or a spouse. And then it's just a nightmare situation because there's assets that were not titled to another person. Basically no one was organized. There was no spreadsheet outlining it. I didn't know what the password was to the bank account. And then it can kind of really slog on. And that's what everyone wants to avoid, right? we try to make this process as simple as possible. Contesting a will. So I am a child of my mother and father, Diane and Mike, and I have a sister named Molly. And I'll use this as an example. We're set to inherit 50-50. But then my mother dies, but right before she dies, she changes the will so that it's 80% to my sister and 20% to me. I might not like that. I might think, hey, I'm entitled to more than 20%. Mom loved me. I never gave her any hassle. Do I have any legal recourse? And the answer to that question would be yes. There's the first question of standing. Do I have standing in court to challenge this will? Am I an eligible party? And there are really two requirements there. One, if you are a named beneficiary under the will or trust, but we're going to keep it in the will realm, if you're named in that will in some way, shape, or form, or if someone would have stood to inherit under the laws of intestacy. So under the statute, there's a number of people who stand to inherit, brother, sister, grandparent, cousin, niece, nephew, depending on whether or not you fall into any of those categories, then you could potentially have standing to bring a will contest. But even if you have standing, it is incredibly difficult to challenge a will in the state of Tennessee, and for any other states. Will contests are some of the most expensive litigations out there because they tend to drag on. I've read cases that have lasted for 16 plus years. But there are 4 major valid reasons as to how you can contest a will. The first is testamentary capacity. Testamentary just means, after death. But capacity. Did that person have capacity to sign a will? We'll talk about that more in a bit. Capacity is not a medical diagnosis for will contest purposes. It is a legal determination. So there's a number of things that have to be considered there. But did that person have capacity to execute documents? There are other formal requirements to a will, right? There has to be a signed writing. It has to be signed by that person executing the will. Or if they cannot physically sign, they have to direct a representative to sign for them. That is also a valid way. And a will also has to be witnessed by 2 witnesses in the state of Tennessee, and there has to be an attestation to those witnesses. And normally in Tennessee, that's a separate document that's included in the back of the will. That's also signed by the witnesses, and it's notarized. And that notary is just saying that these witnesses are attesting to the fact that they did in fact witness the will signing. The third reason is undue influence, and we're going to dive into that a little bit later. But if someone was coerced into signing a will, or if they believed that they were doing something that was really fraudulent, then that also falls into that bucket. And then if the will was forged, or if it was fraudulent in some way, shape, or form. So those are the major valid reasons as to how you could contest a will. What's also important is that you can contest a will 2 years from the date that the will is admitted to court. So that's the statute of limitations that allows you to bring a claim. And there's a number of questions that come with that. Should I wait to contest a will further down the road, or should I immediately file and say I'm contesting this will? I guess it depends. If you contest a will early on, you basically have more time to gather evidence and make your case, rather than not. But those are the major reasons and the timing for contesting a will. Now, testamentary capacity is that first reason that we discussed, and there is a threshold that must be cleared before you litigate undue influence or insane delusion. And you basically need evidence to attest to that. So that could be the witnesses that witnessed your will signing, right? Did this person have capacity when they signed? Did they know who they were? Did they understand what they were signing? Did they know it was a will that they were signing? Did they understand that the will was executing exactly what they wanted, and so on and so forth? Normally, that is in the form of evidence from witnesses on the stand. It can be in other forms as well, but generally it's from those witnesses, and it can be from other individuals. You know, if you have a doctor that claims to state that maybe this person did or did not have capacity at that time, it can get really hairy, but that's generally how it's proved. And this is a line from a case, the state of Elam, and it's, they must know and understand the force and consequence of the act of making the will. So it's really, okay, I understand that I'm making a will and that I'm going to have instructions for when I pass away. And they have to have an intelligent consciousness of the nature and effect of the act. So they know that, okay, this is a will I'm making and that it's going to distribute to these people that I've designated. A knowledge of the property possessed. So believe it or not, that kind of gets glossed over more times than not, but they have to know what they have, right? Because in their will, if they say, I want to give $1 million to my, child, well, everyone wants to give $1 million to their child, but most people don't have $1 million. So it's just, you have to really understand, it's the, but I can't remember there's a phrase for it, but it's like the extent, oh, there it is, the extent and knowledge of the bounties. And so it's basically knowing what is included in my estate and how far that extends. And also an understanding of the disposition to be made, whether that is a specific outright gift or whether that's leaving money in trust in a will for someone, whether that be a child or for someone older. It's understanding, however, whatever I have, how I am leaving it exactly. And believe it or not, this is actually one of the most fought over reasons in a will contest, is that mom or dad or grandpa or grandfather didn't have capacity to execute this will. And that tends to be one of the most litigated issues. There is a factor test in determining whether or not someone has capacity. And the first being is, did that tester said when he or she signed the will? So it's saying, if that person knew that they wanted to sign their will and they said yes to any questions that were asked, whether that individual was literate or not, believe it or not, that has come up time and time again. How much help the individual needed in activities of daily living. Unfortunately, as we age, capacity can tend to dwindle. And so there might be days where you have capacity. There might be days where you don't have capacity. And so that's definitely a factor that the court takes into account. Whether the will makes an unnatural or unjust distribution. I love that word, unnatural. So that $1 million example can be something to look at, but also if it's making, an outright gift to someone who that person has never met, that could be something that could be included. And lastly, the person's age and physical condition, which somewhat ties back into if they needed help with activities of daily living. Again, this is a factor test, so there's no order of operations to any of these. It's simply the court looks at everything, some of these factors and says, okay, do any of these apply? And should they be weighed one over the other? And now, we're going to talk to that third issue, which is undue influence. So, the most famous case is a gun to the head, and you say, sign this will, right? That's the most blatant example of undue influence, but undue influence can come in many different shapes and forms. The most important is actually the first at the top of this list, which is the existence of a confidential relationship. So, if someone is serving as that person's power of attorney, so hypothetical example, mom is signing her will, and as her son, I am serving as power of attorney. And while we're going through the will process, I tell my mom, hey, maybe you shouldn't give my sister 50%. Maybe you should give me all of the money and cut Molly out. And mom says, well, I don't know. And then you say, well, no, I think you should really do that. Mom goes ahead and does that. Technically, because I am power of attorney, I'm the agent under my mother's power of attorney. Undue influence is presumed in this case. So if my sister decided to file a will, formally a will contest in court, there's a pretty good case that she has that says undue influence that, is not only was presumed here, but she can make a very strong argument that it did in fact exist because of that confidential relationship. So that's just very important to note in this case. Other factors are the person's physical or mental deterioration. So whether or not, they're physically handicapped or they've had mild cognitive impairment, dementia, Alzheimer's could come into play. If there's, the beneficiary's active involvement in procuring the will. We've seen this before where someone who's, set to receive a distribution is continuously trying to procure the will and say, let me see it, let me see it. There's also the secrecy concerning the will's existence. So if they try to hide the fact that the will does in fact exist, the testator's advanced age, lack of independent advice is another one. And then the testator's illiteracy or blindness. In fact, again, this ties into physical or mental deterioration. No factor is above the other. But if that person is illiterate or if they're blind and can't read anything that they're signing, that's a really big factor. The unjust or unnatural nature of the will's terms, the testator being in an emotionally distraught state. We've seen this before where people have said, I want to give away all of my money to someone because of some, terrible event that have just occurred or might occur. And discrepancies between the will and the testator's expressed intentions. So if you say, I want to give my children 50% shares equally, and then that could definitely have been changed without the testator knowing. Testator, I'm sorry if I haven't said, testator is just a fancy word for someone that's creating a will. So it's that person signing. If there's discrepancies between those wishes, once they decide to finally sign, let's say they sign thinking it's 50-50 and next thing you know, it's 90% to me, 10% to my sister, mother dies freakishly, and next thing you know, I'm set to receive 90%. There's a pretty strong case there that undue influence did exist because, my mother did not know that that was the case. And last is fraud or duress. That last one speaks for itself in the fraud factor, but also duress. It could be, someone forcing someone to sign a will, saying do this or else. That's definitely a factor to be considered in undue influence. And insane delusions. I love this one. It is not a psychiatric term of art. It is a legal term that the courts have coined. It does not appear in the DSM-5, which is the manual for psychiatrists and psychologists. But it's really, if there is a manifestly false belief that undermines and subverts the will maker's ability to reason. This comes in many different forms. There is a very famous case, I believe it's from 1980, about a person believing that aliens were coming and taking over the earth, and this person wanted to sign a will to give away everything to people other than his family. And you can bring a contest under the insane delusion reason. And that's one of the things. But the important key there is that the delusion that that person is having must have influenced the bequests. So, i.e., the distributions. So if that if that person believing that aliens were coming in and they were, hostilely taking over mankind, that idea somehow have to have influenced the fact that I was set to receive 50% and my sister 50%. So that's the key thing there, because if it doesn't affect the distribution scheme, then insane delusion is not a valid reason to contest a will. And so that's will contests. What are trusts, right? I think people have a somewhat general sense of what a trust is. They've heard the term. I've heard of the term revocable living trust. I think I need it. I've heard of an irrevocable trust. Why do I think I need that? The formal definition, as you can see on the screen, is a fiduciary arrangement that allows for a third party to hold and manage. I want to emphasize the word manage assets on behalf of the benefiting parties. Basically, It's a three-way relationship between this person called the grantor, the trustee, and the beneficiary, right? So think of it as a triangle. The top is the grantor. That's basically you. You know, if you want to put money into this trust, into this bucket, I'll use my cup as an example. Then, you know, house, bank accounts, brokerage accounts, so on and so forth. You as the grantor would put all of those assets into this bucket. The trustee is someone who manages that property. It's the term third party can be used somewhat loosely depending on that, because you can appoint someone to serve as trustee or name someone. Depending on the type of trust, that person could also be you in a revocable living trust situation. Basically, it's creating a bucket for you to manage your assets that can provide a number of different benefits, such as avoiding probate. I'll dive into those in a second. And then there's the beneficiary, which is a person or a class of people that are entitled to receive and benefit from those trust assets. So it operates similarly to a will, right? If you name in your will, I want 50% to go to Adam and my sister Molly, we are beneficiaries under the will. The same can apply for the trust. My mom, you know, creates a trust. She puts property into it. She's the manager. She passes away. My sister and I are beneficiaries that have rights under this trust. One of the major reasons why people decide to move forward with creating trusts is that they're private. So if you have assets that are in a trust and you pass away, your beneficiaries should not, emphasis on the word should not, have to probate a will. There's this magic word I'm going to talk about in a bit called funding. But if you have a will, if you have a trust and assets are in the trust and you pass away, they are specifically non-probate assets because they're privately held in trust and they would just flow to the beneficiaries. It's not an invitation to litigation normally because it is very hard to contest a trust. It's somewhat more difficult than a will because of the fact that this person had, you know, should have had capacity when they signed the documents. They're held and managed by a trustee. Trusts generally are around a lot longer than wills. You know, wills don't take into effect until that person passes away, whereas trusts have been in effect for quite some time. And so the courts tend to look at that and say, if this person created a trust in 2010, they died in 2015, or I'm sorry, in 2025, let's say, and the trust has still been around, the trustee has been managing the property for that long, you know, the beneficiaries, although they do have rights to contest it if they do want to, it is a lot harder to contest. And the other thing worth mentioning is that generally all the legal fees that come from, you know, litigating or contesting a trust come out of that pool of money. And so that's very important. So the longer that that drags on, the more you kind of just chip away at whatever is in that pool. And so you're set to receive less potentially. What another great benefit about having a trust is that it handles property in other states. So you could have a trust in Tennessee, you could own property in Florida, and that property can be owned by the trust. And so if you pass away, that property does not have to be probated in the state of Florida if everything is titled accordingly. And that's normally called ancillary probate. So if you passed away in Tennessee and you had assets in a different state, you might have to do ancillary probate in that other state, depending on the circumstances. Sometimes it's also cheaper and easier for the beneficiaries at the testator's death, aka they don't have to hire an attorney for a consult and say, do I need to probate anything? Because everything's in trust, it would just automatically flow to them if everything is set in stone. And lastly, if you are worried about your spouse's care, or, and I didn't include this word here, but not only spouse, but if you have a family member, right, that's receiving benefits, you can create something called a supplemental needs trust within this trust document. So think of it as like an article or a chapter within that trust that specifically outlines if someone is in a nursing home, or if someone does not have capacity, and I have X amount of dollars or property that I want to leave them, but they can't receive that, how should that be left? Well, you can leave it in a supplemental needs trust that would govern how that property is managed and distributed to them without really affecting any of their benefits if they're receiving, or if they don't have capacity, making sure somebody else can step in and help manage for them. And so that's trusts. And now I get to talk about the magic word, which is funding. And people love creating trusts. I don't want to go to probate. I don't want my stuff being out in public. Absolutely. That is a valid concern that people have. They don't want their information out in public. They don't want their property being disputed by any of the beneficiaries that they have. But it's not entirely true, because all that happens when you sign a trust is you just created a bucket. But what happens if you die and nothing's in this bucket? Then the trust is worthless. So there's some due diligence and some legwork that anybody who signs a trust has to execute. And funding just means making sure that any properties that I own in my name are now in this bucket. So Adam Burke, my name solely, if I want to put them into the Adam Burke Revocable Living Trust, I have to make sure that the deeds to any of my properties state that it's no longer in my name, that it's in the trust name. If there's any, if I have a checking account or a savings account, I have to make sure that it's not in my name, that it's in the trust name. And there's a couple different situations there, but generally that's how it works. It's making sure that any of my assets are appropriately titled in my trust name, so that when I pass away, it does not have to go through probate. There are drawbacks, though, to creating a trust, which is that you generally pay more to create them. And that speaks for itself. They are inherently more complicated documents. There is a lot of legalese, specifically more than what is normally included in a will. And the primary reason for that is that you're creating this document and using it while you are alive. So it lives, right? Whereas a will just kind of takes no place upon death. A trust is used. You can retitle stuff while you're alive. You can take stuff out of it while you're alive. You can revoke it. So there's generally a lot more complicated legalese that has to go into a trust. There is no court supervision. So you might be asking, well, wait, I want to avoid probate. That's why I'm creating this trust. That is true. But if you do want court supervision and you want to make sure that, hey, I want things to flow as is, and maybe I do want to go through the probate process just to make sure that, someone, if they do want to contest the will for whatever reason, I want a judge to be able to check them and make sure that everything's going okay. Or sometimes, generally, you might not have time. That's another big thing. People that are executing estate planning documents, some people find out and they're like, I haven't done this. And they might realize that they don't have much time left. And so that's another reason too. There is no 4-month cutoff with creditors, unfortunately. So you're not putting them on notice. Like I said, remember, when you're probating a will, you have to petition the court. That publication notice is filed. But after that publication notice is filed, creditors are officially put on notice one way or another. That does not happen with trust. So with trust, creditors, if the trust does have any creditors, they can unfortunately come forward at any time. They can open probate or contest the trust assets. And it might mean a longer wait to sell real property, just depending on the nature of what's in the trust and how things flow. And then lastly, I just want to emphasize again, all property, if advised correctly, should be titled in the name of the trust. Some assets, it might not make sense to put in the name of the trust. And there's a term called beneficiary designation. And there's a slide that I'll speak to later, which kind of covers why you might not want to put some assets into the trust. But generally, you do want to put assets into this bucket. I have a slide here for powers of attorney. This is a question I get all the time. Mom's passed away. I'm the power of attorney for healthcare and for finances, or one or the other. Is this power of attorney still good? The answer is no. Upon the principal's death, so mom died, right at that moment, that power of attorney is invalid, specifically for finances. There is an exception, though, for healthcare powers of attorney, because the law provides a right to healthcare powers of attorney to conduct an autopsy should they deem it necessary. So that is the only exception to the power of attorney rule. But other than that, upon death, that power of attorney is null and void. Now, beneficiary designations, the magic of them. These are what we call non-probate assets. And you might read some of these things and think, okay, wait, I thought I was supposed to title these into the trust. Yes, that's the general rule. But if it falls within, the direction of your estate plan that you want, you might not have to put things into the trust because it might go to someone directly. There are a number of different non-probate assets, but from the ones listed, these are the general categories or most seen assets that we deal with. So if any of these have a beneficiary designation or a transfer on death or a payable on death, they basically all mean the same thing. But if someone is listed to receive any of these accounts upon your death or someone else's death, that asset should go directly to them. I'll say that one more time. It goes directly to them. So it does not go to your trust. It doesn't fall into probate asset unless your trust is named. But if I have life insurance and I pass away and I state that I want my sister Molly to receive all of the life insurance, then it's Molly's. She receives it. But if I don't name anybody on my life insurance for some reason or another, then it's technically a probate asset. And then it has to go into my estate. You have to file for probate. It becomes a whole thing. You have to pay a lawyer, and that's what we want to avoid. So it's worth making sure to everyone on this call and to all of your friends and family, please, please, please tell them that make sure that beneficiary designations are updated. It's very important. The same thing works for checking and savings accounts. Normally, when you open an account at a bank, it's listed it's one of the questions on the form. Do you want to name a beneficiary? I would say majority of people have that filled out, but if you don't have it filled out, it's worth doing. Do I want it to go to my spouse or my children, or do I want it to go to the trust that I just created? That's another way to do it. Or you can transfer that into the trust, and then your trust governs however that property is distributed upon your death. The same thing for brokerage accounts. The same thing for IRAs. IRAs are a little, there's a lot of rules that have recently come out with IRAs. I'm not sure if anybody has heard of the Secure Act. It's basically Congress's new foothold on IRAs and how they function and required minimum distributions. So I'm not going to dive into all of that, but generally, if you have an IRA, you should list a beneficiary on that IRA, and that becomes a non-probate asset. I want to speak to real estate, and the general rule is that it generally falls outside of probate. And what that means specifically is that upon death, real estate flows. So you don't have to pause and say, I need to put this in, it's a probate asset. What does the will say? That's generally not how it flows. If there is a joint right of survivorship on the deed, then that survivor would receive the deceased's interests. So I'm married, I pass away, but on the deed, Barbara wants to chime in. Go ahead, Barbara. Oh, you can't unmute yourself. Oh, hold on. Interesting. Try now. There we go.
Okay. Adam, you need to wind up if I want to get a chance to talk about anything.
Sure.
Okay.
Is that all you want to say?
Yeah.
Okay. Yeah. I'm coming to the close. All right. So the last thing I just want to say again, real estate, which is that joint right of survivorship. So if I'm married on our deed to the home that we own, it says myself and my wife, we have joint rights of survivorship in the home. When I pass away, the house becomes my wife's 100% and vice versa. But if we don't have that, then it flows as something called tenants in common. I won't dive into that, but generally, real estate falls outside of probate, but you need to make sure that it is titled appropriately. So if you have a joint right of survivorship on the deed, it flows to that survivor, or you can put your home into a trust via funding. Basically means you retitle the home that you own in your name into your trust name. And so now, Barbara,
Fantastic.
we got time.
Okay, I'm going to briefly talk about this. And I don't have slides on this. We're not experts on funeral arrangements or memorial services, but what we have had a lot of experience with this. So the first thing I want to talk about is the memorial service. The memorial service is for your family. And I had a dear friend who was very humble, and he told his family that he didn't want a memorial service. And I didn't get the chance to tell his family how kind he was to me. So I'm all in favor of having memorial services so that your family can be told how much you meant to other people. Tell your family what you wish, what you want in terms of speakers, in terms of music. I love to see children and grandchildren get a chance to talk, especially grandchildren, get a chance to talk at a memorial service. And write it yourself if you want. It's not a bad idea. Give people some guidance. Now, what about funeral arrangements? Again, it makes sense to plan ahead. It's not going to matter to you, but on the other hand, if you wait and die and your family and there are no plans made, I can tell you that they're going to get pressure when they go into a funeral home to buy the most expensive casket. I remember when my husband's grandfather died, and they said, "We can give you a vault that will never leak water." Well, guess what? Dead people don't care whether the vault leaks water. And if you plan ahead, or at least talk to people, don't spend more than you can afford. I was going to tell a story too about pressure. I had a friend whose sister died, and my friend went with his sister's husband to the funeral home, and they said to the husband, "Oh, if you get this expensive funeral, we'll give you a vacation for two." Okay, whatever. There are people who will come to your house and talk to you about funeral plans and funeral arrangements, cremation, and so forth. And that can be a more expensive and less stressful way to do it. There are three really types. You can have the traditional funeral where you get buried in a casket. You can have cremation. And now there are natural funeral sites. The one in Nashville is called Larkspur. And I just learned today that a traditional Jewish ceremony is one with natural burial. So, I don't know. I've been to Egypt. I've seen the face of a pharaoh that was embalmed 2,000, 5,000 years ago. I don't know. Everybody has their own wishes about that. Now, next slide. We're not experts on grief either. It is a unique journey for every different person. I would say if you're in that situation, remember, no one can tell you when it's time to have recovered. No one is the authority on when you're supposed to get over it. Grief, I saw an article just recently that grief is a learning process. You're learning to live without someone. And a learning process can take different amounts of time. And finally, I do know that Alive Hospice has grief support groups. I would imagine that there are more hospice providers in town that also have that, but I do know that Alive Hospice has it. So at this point, Adam, can we open it up to everybody to share their screen? Oh, we're all just walking each other home. That's what we believe. You're walking me home, I'm walking you home. Okay.
Yes, we can. I'm going to open it up for questions, but in the meantime, I'm going to stop
I will
sharing
say, I
screen.
had a law partner who would say to people, if you come to my funeral, I'll come to yours. It doesn't quite work like that. Okay, questions.
So if anyone has a question, just feel free to either unmute yourself. You can turn on your video if you'd like. You don't have to. And just ask away, and we will funnel accordingly.
Or you could also type it into the chat.
Yep, that's another option if you do have questions.
And have we unmuted everybody? Oh yeah, we have. We have people joining us.
Yes, we do.
Hello.
Hi, Kim. Oh, we can't hear you.
There we go. Adam, you're the host. If you can go to those three dots and ask.
Yeah, let me see.
Unmute
I just
yourself.
asked you, Kim.
Here we go. There we
There we
go.
go.
Okay.
Hi,
Sorry, I'm
Kim.
muted.
Away.
Hi. Is there a time frame where you have to contact financial institutions after death?
No, once they know about the death, they're going to freeze the account. You don't have, I think that you can probate a will anytime within 10 years. So there's no rush.
I've seen it within 10. But sometimes the funds might sit there, like Barbara said, for an indeterminate amount of time. But there's no requirement as to if someone has passed away, let's say a month ago, and you're the executor, is there a specific time frame? No. But if you're named, there's a duty to probate the will. So at some point, if you're not the named beneficiary, someone has to step forward and open a probate.
We've got a question in the chat. What's the difference between an irrevocable trust and a revocable trust? A revocable trust is what is really just a book of instructions that takes place when you die. It's like a will, but you have to fund it. You are the grantor, you are the trustee, you are the beneficiary. So it's like you still own everything. It just doesn't have to go through probate. But it doesn't protect anything from Medicaid. So when things go through probate, if you've been in a nursing home and Medicaid has paid for it, then on the day that your stuff goes through probate, Medicaid is there with their hands out saying, pay us all back every penny. An irrevocable trust is putting your assets into a trust that will protect your assets from Medicaid. So, and who knows which of us will be on Medicaid someday. I hope to be an ornery, demented person that lives a long time. And so an irrevocable trust, first of all, it's not truly irrevocable, because if the grantor, the trustee, and the beneficiary all agree, you can just sign a document and revoke that trust. So you create an irrevocable trust, you put assets into it. That is a gift. And for Medicaid purposes, remember there's a 5-year look back. So if you get to 5 years and 1 day after you funded that trust, those assets have disappeared if you need to get Medicaid to pay for your nursing home care. So those are the big differences. It's pretty complicated. Ramona, if you want, you and I can have a specific discussion about this. You just reach out to me. Okay.
Thank you. Thank you.
Who else has questions? Okay. Well, we have filled up 58 minutes, and thank you guys for coming. It was lovely to have you here. And Adam, you did a great job. And everybody will have another webinar next month. And if I knew the title, I would tell it to you. Thanks.
Thank you very
thanks
much,
a
Barbara.
lot.
I do have a
Barbara
question,
and,
Mrs.
uh,
Ramon.
Wait, wait, we got a question.
Yeah, I'm sorry. Yes, real quick. How do we access the recorded version?
We're going to post that on our website. And I believe there's a page specifically dedicated to recordings.
Okay, thank you.
We're working with our team to have this recording uploaded. If it's not uploaded this week, it should be in the next coming weeks for sure.
Okay, great. Thank you. We appreciate you both. Thank you so much.
elderlawnashville.com. Okay. Thanks, everybody. Stay on a minute, Adam. Thank you, everybody.
All right,
Thank
thank
you for
you.
attending.
And you can stop the recording, Adam.